the best time for younger folks to look at long-term care insurance is roughly between 45 and 55. You would know more than I would. But
Yep.
When you need some advice, never sacrifice, always get it right. Ask the Planman. Finance, insurance, and more.
Hi, everybody. Welcome back to Ask the Planman. I'm your host, Bruce Weinstein. I believe each and every one of us needs to lead a productive life and do all kinds of proper planning. We talk about financial planning, retirement planning. Today, we're going to be talking with Barry Siegel, a local attorney down here in South Florida, about estate planning. And we're going to emphasize and highlight for you specifically the areas around elder care. So Barry, welcome to Ask the Planman. Let's talk a little bit about the generalities of estate planning, but I really want to hone in on what you've been focusing on in your practice is around the elder care side of things. So why don't you kind of define for our listener today, elder care in a sense, like what exactly does that mean, and then wrap it into the estate planning world?
Okay. Well, first of all, Bruce, thank you for inviting me to join you on the podcast today. I can first tell you what elder law or elder care law is, and that is really it's asset protection for people who are in their retirement years, people who may have concerns about the cost of long-term care, and they don't have the security blanket of having the long-term care insurance, or maybe they do have long-term care insurance, but they ran out, or it was, or it's about to run out. And the other option, the third option, besides what elder law attorneys do, helping people get government benefits without spending down their assets, is to use your own assets to spend on the cost of care. And that's exactly what most people don't want to do. People don't want to have to spend down their hard-earned money, their nest egg, so that later in life, either they leave their spouse with nothing or next to nothing. I had that happen. I had a personal situation in my own family where that happened many years ago before I was even an attorney, and that had a major impact on how I got into this.
Oh, that's I can understand that. I find that a lot of my experience over the years in working with clients comes from exactly that, is they have a pain point. They had a situation with a parent, a relative, somebody in their family that went through something that became a big problem and a big challenge. And now it's like, I don't want that happening to me. How do I protect myself from that? So let me uncouple a little bit about what you said here. So we've had some episodes on long-term care. Folks, for those of you unfamiliar, long-term care, we usually will position in the world of insurance around your financial plan, early 50s and beyond. It starts to get a little bit too expensive in your late 60s and 70s when unfortunately, a lot of people start to need it. So we're talking about the need for revenue or income to come in if somebody were to need assisted living, home health care, or more importantly, critical care in an actual nursing home. And so what ultimately happens, and we're not going to get into all the intricacies, is the clients will look at their assets and understand where the government programs do or don't apply, and work with me and do the planning side to try and prevent some of that and maybe put insurance in. But as Barry mentioned, maybe the insurance ran out. Maybe that person was uninsurable at the time, or they just never bought it. And so I would bring somebody in to talk with Barry to now help structure. And that's, I guess, a big piece of the estate planning is all the structuring. It has to do with ownership of assets, right? Who owns what? It's his, it's hers. Who needs the service? And what are you entitled to and allowed to protect? And Barry started it out saying it's a form of asset protection. So does that help frame that up a little bit?
Yeah, I think you did a good job framing it up. And really the biggest challenge when it comes to this elder law is issues that people have where they believe that they have too much in income and too much in assets to qualify for these government benefits. And of course, the government benefit we're talking about is Medicaid, the federal program of Medicaid that's designed to help people who are impoverished, who have very little assets and very little income, get the cost of their care, home care, assisted living, and nursing home care paid for, or at least contributed toward, so that they don't have to bear the full burden of spending all of that money. And so the thing is, elder law attorneys are not needed by people who are already impoverished, because they could just qualify. If somebody is, if the owner of Amazon or PayPal, or if anybody's super wealthy, they're not going to need it either, because they could buy the insurance, the long-term care insurance company, let alone buy a policy or spend,
Elon Musk line too.
Not going to make a difference. But for most people who are not mega wealthy and who are not impoverished, most of America, people who've worked their whole lives, people who've done the right thing, they've saved money, they've done everything they were supposed to do, except one thing happened. Either they or their spouse, or maybe both of them, became ill and needed help with activities of daily living, such as feeding themselves, bathing, toileting, dressing, all of those kinds of activities of daily living. So now they need help. Now they need either someone to come to their home, or they need to go outside of the home to assisted living or nursing home. And now the question is, how are we going to pay for it? We don't have endless amounts of money to spend down. We don't have long-term care insurance, or we don't have enough of it. It's about to run out. So what options do I have left? And that is Medicaid. The thing is, Bruce, and I've heard this so many times, people are going to jump to the conclusion that, we have too much. I have too much income. I have too much assets. That's not for me. In fact, people, when they hear us talk about it, they may even have a little mini daydream and start thinking about something else, because this, in their mind, doesn't apply to them. And what I say to that is, that could be one of the biggest financial mistakes anyone makes in their life. So, for example, if you're listening to this podcast and you hear this, and maybe you have a parent or a loved one that needs care, and you're currently spending down your assets, and you're not even listening when we talk about an elder law attorney helping your loved one qualify for Medicaid, that would be a big mistake. So it's that. And the other thing, Bruce, is people think it's too good to be true. How could I qualify for this? And the thing is, this is what elder law attorneys do. It's completely legal, and it's out in the open. We're not whispering about this. This is something that you're allowed to do. If Medicaid and the government wanted to change the rules, they would. But right now, they have it open, and there are things we can do to help people not spend down their assets and go broke.
Now, the terminology, folks listening, is if you're over 65 and the word Medicare, we're talking about Medicaid. And a lot of times people confuse those terminologies. So Medicare does not cover long-term needs. Long-term care, LTC, has the word long in there. So Medicare will provide for certain short-term levels of service predicated on what happens to that individual. Obviously, they have to be on Medicare, which means they're over 65, not 62 or 63. They're not even Medicare eligible yet. And they have to go through a hospital stay and center rehab. And you can get up to 100 days of some participation with the Medicare side of things. It's not 100% paid for by Medicare, let's be very clear. But there's assistance. After day 100, you're back on your own. And now Barry's referring to the Medicaid. Now, historically, as he was referencing, Medicaid is you were deemed to be broke. It's a welfare for the seniors. But now when you have assets, there's ways to structure, change ownership, which Barry gets into and we could talk more about. But what I wanted to throw in there, Barry, is kind of think of there's 3 buckets of money your average person has. Their house, which is illiquid, where now people will see, and we've had episodes on reverse mortgages and tapping into that asset. So you have your house. You've got retirement assets, 401k, IRA assets, and then you have what's called non-qualified. After-tax money investments, maybe annuities, but people will have money that's more liquid and has a different tax structure. So in sitting with Barry, he knows let's call it the rules or the limits on what things can be done and how things need to be properly structured, where you can position. Look, the biggest fear, Barry, you'll agree, in dealing with people in general, retirement planning, tax planning, estate planning, is everybody's biggest fear is running out of money, right? And so now you're getting to this crossroad where you're 67, you're 77, you're 87 years of age, and now you're hitting that point in your life where more care is now your financial responsibility. Medicare's not paying it. And now you have to dip into that pocket. We always called it the rainy day fund, which is why you wanted long-term care insurance. And that would help pay for the rainy day. You don't have that. So now you need Barry to proactively, right? What we're all about, plan man, proactive, is structure assets in certain designed ways. And he will or won't give us too many nuggets for free today. So hopefully we'll pry a little bit out of them for you. But the whole point is, you don't know what you don't know, right, Barry? And so that's why you're skilled in what you do, and people come to you like they come to us, is you have that expertise. So how would somebody go about, or, what would be, where's that line in the sand? You said like Elon Musk and Jeffrey Bezos, too much money. And then somebody who's pretty much down, below certain levels, like what's the sweet spot? What's the range that most people, they have a home, they have got some assets, retirement plans, like where do you find the majority of people fall that most benefit from your work?
Let me explain how it works, because there's really not a line in the sand. Okay. But the thing is, Medicaid has an asset limit of $2,000 for the person who needs care. $2,000 assets. I mean, for most people, they're going to have more than that. So the thing is, it's not all assets, it's countable assets that can be $2,000, meaning there are some assets that are non-countable and excluded that don't count. So that means that you could have these other assets, non-countable, excludable assets, like your home. Your home, your personal residence here in Florida, your homestead, doesn't count. Also, we can set it up so that your retirement assets, IRAs, 401ks, Roths, all of that, can make that not count. Also, you could have a vehicle. You could also have rental property. So whether it be 1, 2, or 5, or however many, as long as they are actually being rented at fair market value rent. So you can't put your nephew in there and charge him $150 a month and say it's a rental. Okay. So now all of a sudden, hey, wait a second. I don't have to be completely broke here. I could have an account with $2,000 in it. I can have my home. I could have these other properties. I could have my IRA or 401k, which a lot of times people have bulk of their assets in that anyway. Okay. So now here's the other thing. If you're married, Medicaid has a way. There's a way where you can qualify for Medicaid where any of those countable assets you have, let's say that this particular client has all those other things we talked about, but they also have more than $2,000 in their bank or brokerage account. Well, let's say they have a few $100,000 in their brokerage account. We can move that over to the healthy spouse in a way that Medicaid allows. So now all of a sudden, it's still staying within the control of the marriage, but it's just being moved over to the spouse. So again, we don't have to be completely broke. We have the ability to have assets and have access to assets. So with that being said, it's really hard to say there's a line in the sand. So every case is a little bit different too, because other methods that are used, let's say if the client didn't have a spouse, they were divorced, widowed, or never married, they don't have a spouse, there are ways that those assets can be moved to other people, typically children or grandchildren or family members, in a way that Medicaid allows, but we just have to make sure it's done the right way. And so that's important to look at. The other thing to look at is their income, because their income is super important too, because they have a very strict limit of $2,829 a month of gross monthly income. That means income from all sources, and not the net, but the gross. So the thing is, for a lot of people, between their Social Security, maybe they're getting a pension, maybe they have rental income or RMDs from their retirement accounts, it's very easy for some people to be over $2,829 a month. They could be $3,000, $4,000, $5,000, or of course more. So the thing is, typically you wouldn't qualify if you're over that limit, except there is a way to qualify. And there's a legal document that could be prepared, a type of trust, an irrevocable trust that can be created at the time that somebody would need to qualify. But here's the problem, and this is a big thing. You mentioned a few minutes ago, we don't know what we don't know. Here's one example of that is very important. Okay, so let me give you an example. Let's say that there's a family that a single person, they need to qualify for Medicaid. We got the assets handled, but their income doesn't matter, $3,000, $4,000 a month. So that's clearly over the Medicaid limit.
Is it, Barry, let me cut you off. Is it a combined income on both sides, or is it based on the one person again?
It's based on the individual.
Based
on the individual.
So my Social Security is mine, Robin's would be hers. But now if we have joint household income from other avenues, it's a matter of getting that income over to the healthier person.
Right, unless both of you needed it, then there's other rules. But here's the thing. What happens if a 70, 80, 90-year-old person needs Medicaid because they need help, but they don't have their mental capacity? Okay, so we can't put this irrevocable trust under their nose and say you need to sign this so that we can get you qualified because your income's too high. So obviously the issue there is that they need to have a power of attorney, right? But not just a power of attorney, it has to be the right power of attorney. And this is a very important point here. So when this document, let's say the person didn't have their mental capacity, they have a power of attorney naming their son signs as power of attorney. When we submit this document to Medicaid, they're going to say, okay, great, we need to see a copy of the power of attorney. But it's not only to verify that it exists and that they named that person who signed it. Here's the key. They are going to look at that power of attorney and they want to see that there's a specific grant of authority to create this irrevocable trust. If that language is not in that power of attorney, then this is one of the worst things I have to do as an attorney doing this. It's almost like a doctor having to tell a family member that someone passed. I have to tell them, I'm sorry, there's nothing we can do. So if we have somebody who has too much income, they don't have their mental capability, and they don't have a power of attorney, or they have one but does not have this language in it, it's almost like what they say at the end of a video game over, because it's over and there's really nothing we can do. And because they lacked that language in their power of attorney, that was the difference between Medicaid paying for their care or them having to spend their own money down. And the nursing home these days, you could be spending $10,000 to $15,000 a month. Would we rather have our income go towards it and pay $3,000 or $4,000 a month and let Medicaid pay the rest? Or would we like to pay the full amount of $15,000 and spend down our money very, very quickly? So it's super important to make sure that you have the right elder law language in your estate planning documents. They go hand in hand.
I mean, the question's not going to be perfectly answerable, but we talk about when you come in, the line in the sand, age. How about age? Like when I got listeners of all ages here. You got 40, 50, 60, 70, 80. Like, to me, the earlier you get in front of this and have things properly done, the better. And I think what you and I probably have dealt with more often is reactiveness. Is you got somebody coming to you now that's in crisis or about to be in crisis, and you got to unring the bell. And at that point, as you just said, it could be game over, it could be too late, it could be nothing we can do. So I want to stress to the listener out there why we're doing this is always about being proactive. And the sooner you sit down, look, if you're 40 with kids, you still need to talk to Barry about proper estate planning, guardianship of your kids, proper distributions, Q-tip trusts, ILIT trust. There's so much that goes into estate planning, folks. It's not just one size fits all. There's a lot of things that need to be done. And if you don't have a will, you don't have guardianship, you don't have executors, you don't have all these things in place, it's a massive jigsaw puzzle. I know enough to be dangerous, but I know enough to point at Barry and say, you got to go talk to Barry. Like, I tee it up. I see the problems because I'm doing this 38 plus years, but Barry's the one that's got to put it together. You got to sit with Barry. So whoever your financial people are, investments and insurance people, they're not the stop all. They may put certain things in place for you, like the life insurance or the long-term care or whatever it might be, but you still need somebody to help you tuck things into bed and bless it, get the bracha and the motzi, and say, this is copacetic, this is good, this is ironclad. Because you don't want Barry to sit there going, wah, wah, game over, right? Like, you didn't do it right, and now you're stuck. And it could cost you tens, hundreds of thousands, millions of dollars. So, Barry, I'm taking copious notes here. I mean, there's a lot of great stuff you're putting together here for us. I'll go back to the age question, just if somebody's curious, like, when should I come in? I was trying to, browbeat a few of the younger listeners, the 40-year-old with a couple of kids that still don't have a will, right? Like, we could count on our hands how many people we've encountered, over the years that do that. And that's a shame. And that's a problem. Every state is different. I got people that listen, that certainly not just in Florida. State law dictates guardianship, distribution of those kids if something were to happen to both parents. So, it's done at a state level. So you want to have, no matter what state you live in, what county you live in, you want to have at least your basic will. And then if you start to have assets and other components, the estate planning, the trusts and the wills, people like Barry are there to help guide you and grow you into bigger things as life develops. True?
Yeah. And, to answer your question about the age, first, I'll start it with on the Medicaid side. To qualify for Medicaid, one of the requirements is you have to be age 65 or older. Okay. However, there are some exceptions to it. From time to time, we get people who come in that are under 65 that need it. Unfortunately, the requirement to get around that is you have to be on Social Security disability, and then we can do that,
which but usually takes 2 years for people. If you're disabled, to qualify and get on Medicare early, government disability, type programs, as Barry's referring to, is it could be a 2-year window before you even qualify for that kind of stuff. So go ahead.
Yeah, it is a process to get that benefit, the Social Security disability. So that's for Medicaid, but for someone younger who is healthy and doesn't have these issues, it's still a good idea for them to be thinking about their long-term care planning. And I would suggest that, at least what I've always understood, the best time for younger folks to look at long-term care insurance is roughly between 45 and 55. You would know more than I would, but that's like the most ideal time. So if you, and even though we help people get government benefits through Medicaid, one of the things is, if you can get long-term care insurance, if you can get it, because they underwrite you, it's, based on your age and your health and all that. But then also, if you can afford it, if it's not going to cause you to not put food on the table or, not be able to pay your other bills, then I would strongly suggest that people get it, especially if you're in your, 40s or 50s, and if you could still get it. And that's because even for myself, I have it. I've had it a long time. Why? Because even though I know my way around Medicaid, and if God forbid that ever came to be that I needed some kind of assistance with that and get Medicaid benefits, what if they change the law? What if it's not available in X number of years when I would potentially need it? So I want to have that long-term care, but I would still run into that same issue, because the long-term care is not endless. It does run out. So that's important. So what I'm saying is, Bruce,
I'm sorry, they used to offer lifetime benefits with long-term care, and a lot of that has been squeezed. So what Barry's alluding to is, most people will buy up to a 5-year plan. So what happens if they're there more than 5 years? Back when I first started doing long-term care in the 90s, they offered lifetime benefits. And I only sold and recommended to clients from an affordability standpoint. Well, why wouldn't you cover the open-ended? Like, why only take 3 years or 5 years? But, the carriers have eliminated that open-ended exposure. So just to reiterate there. And then there was a piece I wanted to hit on when you're talking about the Medicaid side. And this is what I talked about for many, many years in my workshops, my retirement planning seminars, and we're going to talk about yours before we let you go, is quality of care and choice. When I'm writing the check, I'm going to pick the better facilities. I'm going to have a private room. I want to go to the Bahamas. Like, I can pick anywhere I want to go. When you're on Medicaid, you're on government cheese, and that quality and decision-making is not always going to be yours. You could be in a room with 5 other people. You know, you're not going to have access to a private room if you're on Medicaid paying the bills. So you're going to lose certain levels of quality of choice. But tell us more about the proactivity. I'll kind of jump in and fill in some of the blanks, make sure from my notes I took while we were talking. But
so the key thing is to plan now, especially if we're talking about the Medicaid. Plan now, because the best thing is to have options. Because if somebody comes to us who didn't do any pre-planning, and somebody calls, hey, my mom's in the hospital, or my mom's in a nursing home, or about to go in, and then we have to take that case and look at it, and we have very little wiggle room to do anything to plan ahead. So sometimes I may have to have that unfortunate conversation and say there's nothing that can be done. Sometimes there's things that can be done, but it would have been more advantageous had we planned ahead. So it's always a better idea to plan ahead. And one of the things we'll do is we'll review the situation, let clients know what if anything they need to do now to make sure that they're prepared for the future from a Medicaid standpoint. Now, the things from a estate planning standpoint, you mentioned earlier, the 40-year-old mom and dad, they have some young kids. Of course, that's super important to do your planning. And if for no other reason, the fact that you have minor children, and what happens if something happens to mom and dad, what are we going to do? Who's going to be the person to take care of the kids? Do we want some judge choosing who that's going to be, or do you want your documents to say specifically who is going to take care of your children as guardians, and also who's going to handle the money for them while they're minors or while they're at an age below the age that you're comfortable giving them full control over? So those are just some of the things. We want to make sure we avoid probate and guardianship. And we also want to make sure that we leave the assets to the beneficiaries, typically, let's say the children, in a way where they get it, but they're protected in the future. Even if they get married and then subsequently get divorced, we don't want their divorcing spouse to walk away with half of those assets because mom and dad didn't do an estate plan properly. They went to, one of those online LegalZoom kind of things, or they, went for the bargain basement attorney.
Not Siegel Law Firm. Not Siegel Law Firm.
Siegel Law Group, yeah. Yeah, so you want to make sure you get it done right. And one of the things that's, I think, important, Bruce, it's not just the documents. It's going to be what's the process that the firm is using to make sure that we have a plan that's going to work when we need it to work. And one of the things that we do, our clients can vouch for this, we have a free review every 3 years with our estate planning clients. And that way, that gives us the opportunity to get back in touch, find out what's going on, because life goes on after you sign on the dotted line and sign the documents. And that way, we're going to be able to be in touch, find out what's happened. Have we lost anybody, any new people, any new births, any marriages, divorces, things like that? What if their finances have changed? What if the laws change? And also, as you know, with the trust, you have to fund it. So even if somebody comes in and they sign their documents and they do everything they were told to do, they go to you to change their brokerage account to the trust, they go to the bank, they go everywhere else. And now they did everything right, and then life goes on, and in between those 3 years, they bought a cabin in North Carolina, they opened a new account with you, whatever it is, and let's just say they forgot to put something in, especially if it's that real estate. You know what's going to happen? They're going to have a second probate because that they're going to have to open up a Florida probate and an ancillary probate in that other state. So now it's twice the nightmare. They have to hire another law firm in that other state. So it's very important to have a process to make sure that you have a plan that works when you need it to work.
We got a lot of snowbirds down here, got a lot of people that keep second and third homes, and God bless them for their abilities to do so. But as Barry's just sharing, it opens up different problems or challenges when it comes to the estate plan, and then where the domicile is, and truly what was the residence. Because if you inadvertently didn't get your days in a certain state, or you didn't change, how many people I come down here, they haven't changed their driver's license. They still have their New York or New Jersey plates on the car. They've been here for years. Like, you're jeopardizing how you're viewed from a domicile standpoint. And now you're going to get sucked into New Jersey's estate taxes, or God forbid, New York's, which is, horrible compared to Florida's. So, there's a reason people move to Florida, right? And Texas and other states that have no income tax. And lo and behold, that impacts estate taxes too, doesn't it? Right? So the income tax and there's federal and there's state. So look, all this stuff here, folks, we're not trying to confuse you. We're really trying to promote how most of the time Barry and I are brought in a putting out a fire situation. The horses are out of the barn, and now we're trying to figure out what's left to help solve or fix the problem. And boy, it would have been a lot easier 5 years earlier if you come to Barry and sat down proactively as early as possible, regardless of the costs. There's cost and there's price. So there's a cost to put the work together, but the price can be enormous if you don't have it properly structured and properly planned, and you pay hundreds of thousands and millions of dollars unnecessarily. Because what? Because you wouldn't sit with somebody for a couple of hours and let them do the proper planning for you, whether it's a financial plan, a tax plan, an estate plan. Like, it all coincides together, folks. That's why I'm sitting here pounding the table about being proactive and having a plan. The plan doesn't end at a certain point in time. Barry's talking every 3 years. We talk about life event. When you have a life event, you tell your insurance person, you tell your financial person, you tell your tax person, you tell your estate planning person, because now they need to know, what does that mean? You added another child. Is it properly structured? I lost somebody. I lost my spouse. I lost my executor, Barry. My executor died before I did. And now you have no executor on your documents. You better tell Barry. You better get that fixed. Now they have an estate plan with no executor. Now what's going to happen? Right? There's so much mishigash. There's so much baggage and stuff to be dealing with here that we want you to be proactive. So, Barry, you, like I, are very strong in the education sense. I've built my business over the years doing workshops and financial planning seminars. So what kind of stuff do you offer people to get a taste of Barry, as we like to say, is like to understand things? So I know you offer some online, or I don't know if you do in person, but how can people learn more or sit in with you? What do you offer them? How can they get in touch with you?
Sure.
And also, I'm sorry, and outside of Florida, do you work in other states? I don't know what your group provides.
Our firm operates throughout the state of Florida.
Okay.
Our main office is in Boca Raton. We also last year opened up in Naples, Florida. So we have an office over there. And then we have satellites throughout South Florida, West Palm, Fort Lauderdale, Plantation, Coral Springs, and so on. So we're all over Florida. And then as far as education, we do workshops. And essentially we're doing them here in Boca Raton every 2 weeks. We actually have one scheduled for tomorrow, but then we're also beginning them again in Fort Lauderdale. We do them every 2 weeks in Naples, and probably West Palm Beach is coming soon as well. So we do them every 2 weeks. They're free. It gives you the opportunity to come to our office, come meet us, see how we work, meet our team, meet me, meet our other attorneys, and then to really learn some things and see if you like us, see if what we say makes sense. And if it does, you'll have the opportunity to schedule your free consultation to meet with us. And some people want that educational component. Some people don't. If you're somebody listening here today or watching this on video and you're like, I need to do this, you can call our office and schedule your free consultation. You don't need to go through the seminar process. It's there for you if you want that education and you want to check us out before doing that. But again, the consultation is free, no charge, no obligation. And we go through everything. We ask that if you have existing documents that you bring them in so we could review them. We have a very short questionnaire that you could fill out when you come in, and then we go through. We want to know about what your goals are. We want to know about your family and your estate so we could make some proper recommendations, and then take it from there. We want to be your planning law firm for life. And that's why we do the free reviews. That's why we also do a free post-death consultation with your successor trustees to make sure that your plan is going to continue to work that way. Because let's face it, most people that we name, typically our children, have never done this before. Right. So they need to know what to do. And so we want to give them guidance there as well.
So my natural market is the Northeast, right? I'm from New Jersey, went to school in Pennsylvania, New York, New Jersey, Connecticut, tri-state area. And those are the biggest influxes, certainly since COVID, that have driven down here. So for those listening outside of Florida, if you're contemplating moving to Florida or any other state, you want to seek counsel with a professional in the arena of estate planning to understand the new state, the rules, the regulations. Your New York estate plan is a little bit obsolete when you move to Florida because you want to have Florida law and procedures written into the documents and have it properly structured. So somebody moving down, don't just assume, hey, I got my plan done in New Jersey and I'm good to go. No, you need to sit with Barry or another estate planning professional in whatever market you're moving to, and make sure all your documents are up to the specifics, not just federally, but state, because that has a big ripping effect, right, Barry? If it's not done properly, the state's going to take money that you didn't necessarily need to give away. And then the rules, the guardianships, all the stuff Barry's talking about ties in differently in every state you go to. So if you're contemplating coming down, you definitely want to work and get a consult with somebody in the legal realm to make sure your documents are up to speed. So Barry, what phone number, email, what's a good way for somebody to get a hold of you and the firm?
Our phone number, our main number is 561-955-8515, 561-955-8515. Our website is siegellawgroup.com, SIEGEL lawgroup.com. And so you can schedule right from there, or at least contact us and we'll get you scheduled, or you can call our office and we'll get you on the calendar. You'll come in for a free consultation, bring your documents with you, and we'll see if we can give you that peace of mind that you're looking for, because that's really what it's all about.
All right, terrific. And of course, if you lose track of that, always reach out to us at Ask the Planman, 844-PLANMAN, Bruce at asktheplanman.com. Again, we've been speaking with estate planning professional attorney Barry Siegel here. We were focusing today's conversation more on the elder care side, asset protection, how to position yourself properly if and when the time comes that you can qualify for Medicaid without spending down your assets, without leaving your spouse or significant other broke and destitute and spending all that money down, that there's ways to do this properly. But as we always talk about, you got to be proactive. You got to put this stuff in place beforehand. That lets Barry and other professionals have all their tools available to you. You come to them after the fact in a reactive mode, certain things and strategies are going to be eliminated because it's too late to do them. And that's what Barry talked about today, just like I do, is being proactive. So thank you, Barry, so much for joining us today, folks. It's another episode of Ask the Planman. Hopefully you picked up a couple of nuggets here to take away. You have an elderly parent. You are an elderly parent. You're dealing with situations. Please seek out Barry. Get some help here. If I can help in any way, we'll certainly put you guys together. Another episode of Ask the Planman. If you need some advice, always get it right. Come ask the Planman. I'm your host, Bruce Weinstein. Until next time, make sure you keep tabs and stay proactive. We'll see everybody next time. Thank you, Barry.
Thank you, Bruce.
When you need some advice, never sacrifice, always get it right. Ask the Planman. Finance, insurance, and more.